Okay. Assalamualaikum warahmatullahi wabarakatuh. Welcome everyone for the third BIS International Conference. So here I'm going to present about our research result about the disgorgement in Indonesian competition law. Uh, so here it is. We're going to talk about disgorgement in Indonesian competition law. And we're going to talk about a little comparative approach following the job creation law enactment in Indonesia. Myself, let me introduce myself. My name is Unisulasi Putri. Uh, I'm a lecturer in Universitas Ahmad Dahlan, as well as Vina Damayanti is my second author here. She's the student in Universitas Ahmad Dahlan. So this research came up from the idea about four key discussion here. First is about disgorgement. So well, actually, disgorgement and sanction here are um, two alike keys of discussion. So when we are talking about disgorgement, we are actually talking about sanction. And the second one is competition law, and the third about key discussion of job creation law, which is the new regulation, and people know it as an omnibus law. So the background of this research came up from the idea that everyone has actually the same rights to participate in economic activity with healthy, fair, effective, and efficient business climate, which is it means that everyone has the same rights to do business activity and it shall be granted by the regulation. And therefore, Indonesia issued the regulation in 1999, the law number 5, 1999, concerning the prohibition of monopoly practice and unfair competition. And from this law, after 20 years, you can see it's 1999, which means that it has been like 20 years something. Yeah, 2022 somethings of the law. And you can see that on the law number 5, 1999, before the amendment in the job creation law, you can see that there are two kinds of sanctions. So what most important of sanctions is to uphold the law or regulation, right? Because when the regulation has no such kind of sanction, it's going to be difficult for the law enforcers to uphold the law. And therefore, the law number 5, 1999, governs about the administrative sanction as well as criminal sanction. As you can see, Article 47 here, before the amendment, it regulates the minimum fine of the sanction, which is 1 billion, and maximum fine of 25 billion. And the maximum fine of 25 billion here is considered as too light. Why? The research in 2017 results in the uh, you know in the fact that the number of fine which is collected by the commission of in Indonesia is KPPU, or commission who has the authority to supervise the competition, issued the research result that the number of fine collected by the commission is actually very low compared to the cases that is handled by the commission. And therefore, the new concept is uh, the new concept in the job creation law in law number 11 2020 was emerged, which is in 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 some terms it is called as disgorgement, but the term disgorgements uh, is quite um, unfamiliar in Bahasa, because that is actually the term in English term, which is firstly known in the Financial Services Authority regulation. And the regulation was concerning the capital market or within the capital market context. It regulates about disgorgement and disgorgement fund in capital market, which is in Bahasa it called as pengembalian keuntungan tidak sah dan dana kompensasi kerugian investor. So the new concept that is brought by the job creation law, you can see in, I'm sorry, you can see in law number 11, 2020, especially in Article 118, which is the regulation. In Article 118, it amend the law number 5, 1999. It says that um, the maximum fine of 25 billion is no longer regulated under the law. So it only governed the minimum fine, which is 1 billion. But again, the criteria, amount of and procedure of imposing the fine is regulated further in the government regulation, which is then in 2021 was issued GR, Government Regulation number 44, 2021. So what are we going to talk about here is how is the opportunities for the disgorgement concept in Indonesian competition law compared to the other states' best practices, and what disgorgement sanction in Indonesian competition law aims for. So what is it aims for, or what are the proposals for this new concept of disgorgement? This is normative legal research, and it's the data collection or the data was collected by library research, and of course we have primary, secondary, and tertiary legal research. And further, this research would like to give a descriptive qualitative research where the research would provide a description of how disgorgement in Indonesian competition law and other states' best practice, as well as the aims of disgorgement. So we're going to talk first about what is disgorgement. In Black's Law Dictionary, it says that disgorgement is actually the act of giving up something, such as a profits illegally obtained on demand or by legal compulsion. Further, in Indonesia, where it is firstly known, the FSA issued the FSA regulation, which says that disgorgement, or in Bahasa it's pengembalian keuntungan tidak sah, is the order to return the illegally obtained profit or avoided loss by the party who conduct and or cause the violation of capital market regulation. While in Indonesian competition law version, so previously was the broad version in Black's Law and then in capital market context, and now in Indonesian competition law version, it is governed in Article 6 of GR, government regulation that I said before. It says that the commission here means that the commission, the supervisory commissions of unfair competition, the commission has the authority to impose administrative sanctions. And the administrative sanctions are divided into several kinds. You can see first, second, third, and you can see for the seventh one, which is the imposition of a fine of at least 1 billion rupiahs by taking into account the provisions concerning the amount of fine. So yes, it only regulates the minimum number, which is 1 billion. So what about the maximum, or to which extent the commission can impose a fine to the wrongdoer? You can see in the next regulation, in the next article, which is Article 12. It says that it should be based on a maximum of 50% of the net profits obtained by the business actors, or 10% of the total sales. So you can see here that first most important thing is that there is a violation, and after the commission stated that there is a violation, then the commission may impose an administrative sanction in a form of fine, which is based on which the calculation should be based on, or it at least maximum is 50% of the net profit. So it could be the standard that the commission can impose a sanction or administrative fine based on the illicit profit that the business actors obtained from the wrongdoing activities. As further, the determination of the amount can also be based on the negative impact, which is caused by the violation, the duration of time, mitigating factors, burdensome factors, or the ability of business actors to pay. Here, there are some best practices. Well, I'm not sure whether it's correct terms to say it's a best practice, but mostly some other states also um, recognize the concept of disgorgement, which is first is in China, in Turkey, where China says that when there is an when there is someone who caused the damages to other, then the injured party shall bear the responsibility for compensating the damages. So it is in terms of the compensation. In Turkey, you can see that anyone who, through unfair competition, suffers injury as regard to his customer and so on, they are entitled to the compensation. Well, yes, it is in terms of compensation where there are those who suffered injuries. But in Croatia, is likely uh, a little bit alike to Indonesian, where the disgorgement is considered as a fines, where in Croatia there are three categories. The first two categories concerning to the agency to collect a fine 1 to 10% of the previous year's net profit, which is way lower than in Indonesian standard, which in Indonesian standard it says 50% of maximum. So the third category relates to monetary fines, where the business actually should pay to the state. And well, here is the extension of the the disgorgement term in the United States of America, where I believe it's a little bit 2 or 3 years recently. There was a case of Kokesh, but the case was in terms of a capital market. They recognized the disgorgement as a remedial action, which the remedial action in Kokesh was adopted by Indonesian government, and it is regulated or it is stated clearly in the FSA regulation number 65 2020. But that is in the capital market context. So what about in Indonesian context? So this one should answer the second uh, legal research problem, where Indonesia accommodated the concept of disgorgement in regards with or in terms of the fines, imposition of fines as an administrative action. Well, here you can see that the Business Competition Supervisory Commission or the commission may impose the administrative fine, where it should be based on the net profit or the net sales, and you can see on how it could be based. It could be the legal basis for the commission to impose the fine sanction based on a certain illegal action or illegal profit that obtained by the business actors. So from the discussion, you can see that, well, imposition of administrative fines in business in Indonesian competition law is relatively new, and therefore its implementation needs the attention of various parties. And for the commission itself or the KPPU, the determination of the imposition of fines needs to pay needs an attention. Of course, it should be relates to the effectiveness and efficiency in the business competition climate. And for the further studies, it requires a further academic research and academic discussion about the disgorgement itself. So those are my research, my mini research results, and we do hope for a lot of feedback from you. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.